Hello everyone and welcome back to another weekly update. I have missed you all. I've been away on holiday. I appreciate my weekly updates have now become every once in a while updates, and I hope you can forgive me for that. But I have come back with some valuable information, so let's get started. If you haven't seen me before, my name is Amy. I run an HR and employment page across social media platforms. I'm an HR consultant. If you need any services related to HR, you can check out the description box below. We're going to start, as always, with the Employment Rights Bill. So on the 1st of July, the government published a roadmap for phased delivery of the Employment Rights Bill. The CIPT has been calling for this, so they will be very pleased, and I think it's absolutely a sensible route of implementation. Anything else may completely overwhelm businesses and employees alike. So the roadmap outlines that the government are going to be using the time for consultations, and they've outlined the dates proposed for the employment law changes. There are two coming in with immediate effect, awaiting royal assent, and those are the repeal of the Strikes Minimum Service Levels Act 2023 and major parts of the Trade Union Act 2016, and new protections preventing dismissal for participating in industrial action. Next, we're going to move on to April 2026. I appreciate that I'm moving fast. Feel free to pause or slow me down, or check out the description box below where I'm going to post further details. So April 2026, we've got the Protective Award for Collective Redundancies, doubling the maximum period, Day 1 paternity and unpaid parental leave, enhanced whistleblower protections, the establishment of a Fair Work Agency, statutory sick pay improvements, the removal of lower earnings limit and waiting period, and simplified trade union recognition and digital workplace balloting systems. Then we're going to come on to October 2026. So October 2026, a ban on fire and rehire, although there have been some amendments to soften that, which I'll come on to shortly. The launch of a fair pay agreement negotiating body for adult social care, stronger tipping laws, the employer duty to take all reasonable steps to prevent sexual harassment, expanded trade union rights, and then 2027, more changes. I will put the link to the roadmap where all of these are listed in the description box below. But the most infamous as part of this list in 2027 is the Day 1 unfair dismissal right, which was expected to come into effect October 2026, and now that's been pushed back to 2027. And moving on to today, the 8th of July, we've woken up to a list of amendments to the Employment Rights Bill published overnight. Remember, these are not agreed. Some are more likely to be agreed than others. So the most interesting being banning NDAs, including in settlement agreements, which cover harassment and discrimination at work. As a result, employers will be required to review their documents, agreements, settlement agreements, so there's no attempt to enforce confidentiality of disclosure. There is exception, and employers should always seek legal advice when drafting such agreements. The next one is to soften the ban on fire rehire. This is a complex one, but basically the government are proposing to not place what seemed like an outright ban on fire and rehire, but instead to ban what are referred to as restricted variations, basically a category including changes to hours, pay, annual leave, variation clauses. The most important takeaway from this proposal from the start has always been and remains the importance of the construction of a contract of employment. This is still paramount to provide employers with as much flexibility as possible. Next, we've got major changes to whistleblowing laws. A few key features of the amendments on this are currently disclosures can be enough where the worker reasonably believes it to be in the public interest. The change would be that it actually has to be in the public interest, not reasonably believed, and a new office to be established to be a support for disclosures and heftier penalties for subjecting a whistleblower to a detriment. There's also changes to zero-hour worker proposals, changing the obligation from an employer to offer guaranteed hours to a worker to request guaranteed hours, amongst other factors. And finally, a new miscarriage leave, extending bereavement leave to a stillbirth or loss of a child in the first 24 weeks of pregnancy. I've put the link to the amendments in the description box below so you can have a look in further detail. But now let's move on to tribunal news. Okay, so another week, another NHS tribunal. I mean, by the size of the NHS, you'd expect more than other organisations comparatively, but still, they do come thick and fast. This one involves a disabled NHS employee who worked as a medical secretary. Kelly Ruddock, a disabled employee at West Suffolk Hospital, has been awarded over £233,000 after an employment tribunal found that she was unfairly dismissed and discriminated against by the Norfolk and Suffolk NHS Foundation Trust. Ruddock, who began working for the Trust in 2017 and had previously served as an agency worker, lives with serious health conditions including fibromyalgia and long-term spinal injuries from a crash. Her conditions often caused intense pain and occasional immobility. In 2021, following an administration review, Ruddock was informed her position would change to a senior ward administrator role. one that would require her to work on the hospital ward. Due to her disabilities, this environment was unsuitable and posed serious health risks. An occupational health report confirmed that her concerns were valid. But despite applying for another role into the Trust's redeployment policy, which is specifically designed to support staff with health issues, Ruddock was passed over in favour of a candidate not requiring redeployment, and the Tribunal found this decision breached the Trust's own policy and that she should have been given the alternative position. The panel concluded that the Trust failed to make reasonable adjustments for Ruddock's condition and that the shift to a ward-based role was never clearly communicated as non-physical. They ruled that had this been properly explained, Ruddock would likely have remained in her position and not resigned. The Trust acknowledged that a ward-based environment would have put Ruddock at a substantial disadvantage compared to non-disabled staff and issued an apology for the distress caused. In response to that ruling, Jeremy Over, Chief People Officer at the Trust, stated that changes have since been made, including the introduction of a new reasonable adjustments toolkit aimed at better supporting disabled employees and preventing similar cases in the future. I think more interesting on this case, though, is who pays for tribunal awards in the NHS. So the NHS has a resolution pot, which is basically where trusts pay towards the cost of medical negligence claims. But I believe, and somebody correct me if I'm wrong, this pot also pays for employee claims. And if so, that's taxpayer money funding these failures, which makes them even more enraging. Let me know if I'm wrong on that in the comments. I need to do some more research. And the next case we have is headed to the Supreme Court. Foster carers are demanding to be considered workers and therefore to receive annual leave and sick pay. It begs the question, is foster caring a job? And if so, who is the employer? And if they are a worker, are any relevant employment laws applicable to them also? What about restrictions on working time, national minimum wage, etc.? In January, 3 foster carers won a landmark legal case with the tribunal judge ruling that they had the right to bring a discrimination and whistleblowing claim to an employment tribunal. Now they're taking their fight for full employment rights to the Supreme Court. Some local authorities say, well, they're not actually employees, they're self-employed, so we don't have to treat them like employees. We can call them in when we need them and get rid of them when we don't. That's their argument. Regardless, there's a lot of anger growing over the rise of private equity in the sector. Nearly a quarter of all foster placements in England are now provided by private companies, making millions in profit. Foster carers say they're being squeezed while corporate agencies cash in, and foster carers are at a record low. So what do you think? Should they get sick pay and annual leave? Is foster caring a job? If so, what happens in terms of the other legal rights? Do they qualify for working time? Do they need to have certain days off per week? Because some of them say they're working 24 hours a day. That's what's heading to the Supreme Court, and it'll be an interesting one to follow. And that's all from me this week. I hope you enjoyed the video. Let me know if you did in the comments. Take care. I will see you all again soon. If you want to keep up to date on a more regular basis with HR and employment law, check out my Patreon. The link is in my bio, where I post pretty much daily tribunal news, employment rights bill news, employer guides, everything else goes on my Patreon. Okay? Thank you so much, guys. Take care. Goodbye.